Hello, dear students. Today we are going to discuss essentials of valid marriage under Muslim law, part 1. There are four essentials of a valid marriage under Muslim law. The first one is that the parties to the marriage must be competent. The second one says that the consent of the parties or their guardians must be free. The third requirement is that the required formalities are duly completed. And the last one, that is the fourth one, it says that there must not be any prohibition or impediment in contracting the marriage. Now let us study one by one. The first one, the first requirement is that the parties to the marriage should be competent. What is the meaning of being competent? There are many parts of this requirement. The first one is related with the age of the party. According to Muslim law, the age of marriage is the age of puberty. Age of puberty is an age at which a person is supposed to acquire the sexual competence. According to Hidayah, the famous book which I have talked about earlier also, the earliest possible age of puberty with respect to a boy is 12 years and with respect to a girl is 9 years. This is the earliest possible age, remember. But this cannot be treated as absolute rule. It depends on several other factors. Attaining the age of puberty depends on the, the conditions of the family, the environment in which the person lives, the kind of food habits he has, the kind of friends he or she has. All these factors, together with many other factors, play a very important role. Therefore, there cannot be one uniform rule by which one can gauge the age of puberty. Keeping in view the practical difficulty of ascertaining the age of puberty by physical features, the courts in India have presumed that the age of puberty is acquired on the completion of 15 years. This is the general rule which the courts in India have presumed. This is the yardstick which the court has fixed. And this is a rule of convenience, as a matter of fact. The same rule may be applicable in respect of the age of a boy. Remember, in the absence of any evidence to the contrary, a Muslim is presumed to have attained puberty at the age of 15 years. This is the age of marriage under Muslim law. The requirement of the age of puberty is essential for two reasons. First, the competency for consummation of marriage, and the second one is the capacity to give free consent. Minors' marriage is valid only with the consent of their guardians, and the guardians for contracting the marriage of a minor are, according to Sunni law, father, and after him, the paternal grandfather, how high soever. Third one is brother or other male members of father's family. Fourth one is mother. And the last, maternal uncle, aunt, or other maternal relations. However, according to Shia law, only father, and in his absence, paternal grandfather, how high soever, is entitled to give consent. One very important thing must be noted is that the guardians for the marriage must be distinguished from the guardians appointed by court. The guardians appointed by court for the protection of minors' person and property has no right to contract minors' marriage. In the absence of a nearer guardian, the remoter guardian has no right to contract the minor's marriage. How do we determine who is nearer and who is remoter? It is determined by looking at the list which we just have seen in the previous slide. That list is in the order of preference, and the same order should be followed. First of all, The nearer one is the one who is mentioned at number 1, then comes the second one, then comes the third one, and fourth one, and so on and so forth. This is the order of preference. And on the basis of the order of preference, nearer guardians or remoter guardians are determined. The next very important factor with regard to the competence of the party is the soundness of mind. At the time of the marriage, both the parties, according to Muslim law, must be of sound mind. Persons of unsound mind are incapable to enter into contract of marriage on their own. Remember, on their own they cannot enter into a contract of marriage. As you know, unsoundness of mind is of two kinds, generally. The first one is idiocy. The second one is known as lunacy. Idiocy refers to abnormal state of mind in which a person is completely incapable of knowing the legal consequences of his activities. Such persons are called idiots and they cannot marry on their own. This is generally incurable. Idiocy cannot be cured, and therefore that person does not understand the consequences of his activities. However, in case of lunacy, the situation is different. Lunacy is a mental disease which may be cured. Lunatics have no understanding, but sometimes they may behave like sane persons. It is curable, and during some time when they are mentally normal, they don't behave like lunatics. The period during which a lunatic behaves like a sane person with normal understanding is called lucid interval. Marriage by a lunatic during lucid interval is a valid marriage. Remember, marriage by a lunatic person during lucid interval is a valid marriage, because in that period he behaves like a normal person with normal understanding. The third requirement relating to competence of the party is the religion of the parties. Religion is very important from the point of view of marriage in order to determine who may marry whom. Normally, Muslim law says that both the parties must be Muslims, irrespective of their sects and subsects, meaning thereby two Muslims can marry with each other. It doesn't matter which sect they belong to. That means that a Shia Muslim can marry a Sunni Muslim. Similarly, within the Sunni community, Hanafi can marry Maliki, Maliki can marry Shafi'i, Shafi'i can marry Hanbali, and in this way, you can make any permutation and combination, marriage is possible. The bottom line is that both the parties should be Muslims. If they are Muslims, they can marry. Their sect and subsect is immaterial. The marriage between different sects is perfectly valid. The marriage of these people who are of different sects is called intersect marriage. And the marriage between a Muslim and a non-Muslim is called inter-religion marriage. Now, let us try to understand some situations where the religion of the parties are different. Let us try to understand what Sunni law says and what Shia law says. Under Sunni law, a boy is allowed to marry a Muslim girl of any sect and is also allowed to marry a Kitabiya girl. Remember, I am repeating it. Under Sunni law, a boy is allowed to marry a Muslim girl. Fine. Boy is a Muslim, the girl is a Muslim, marriage is possible. They may be of any sect. A Sunni male, a Sunni boy, is allowed to marry a Kitabiya girl also. Now the question arises, who is a Kitabiya? A girl is Kitabiya if she belongs to a community, the origin of which is believed from a heavenly revealed kitab or book. Muslims believe that not only their religious book, the Holy Quran, but some other books were also revealed by God on various prophets. The followers of those books are called to be Kitabiya. Kitabi or Kitabiya. Under the law, Christians and Jews are regarded as Kitabiya communities. Hence, a Muslim man can contract a valid marriage with a Christian or Jew woman. If a Muslim man marries with a Christian or Jew woman, the marriage is valid. If a Sunni male marries a female other than Kitabiya, the marriage is not void. According to most of the writers, the marriage is not void. The man is a Sunni male, but the female is a non-Muslim and non-Kitabiya. According to most of the writers, the marriage is not void. Then the marriage is only irregular. In Urdu, they call it fasid marriage, fasid nikah. So, in this situation, the marriage is merely irregular, not void. An irregular marriage is neither valid nor void. It is something in between. As soon as the irregularity is removed, the marriage becomes valid. The marriage of Muslim with a fire worshipper, that is Parsi, is mere irregular. Most of the writers say that it is mere irregular and may be regularized and treated as valid when the girl converts to Islam. Shia law is very different on this issue. Shia law says that a Shia male has no right to contract a marriage with any non-Muslim or Kitabiya. That means a Shia male cannot marry a non-Muslim woman, whether a Kitabiya or non-Kitabiya. He cannot marry in the nikah form. In the nikah form, he cannot marry with any non-Muslim girl, whether the girl is Kitabiya or non-Kitabiya, doesn't matter. If the girl is non-Muslim, a Shia male cannot marry. And therefore, marriage with Christian, Jew or Hindu or Parsi girl is void according to Shia law. But a Shia Muslim may contract. This point you must note. A Shia Muslim may contract muta marriage. That is a temporary marriage. We will study about it. A temporary marriage with a Kitabiya female or a fire worshipping female. So muta, that is a very, very peculiar kind of marriage, which is called a temporary marriage, is possible with a Kitabiya female or a fire worshipping female, that is a Parsi female. Shia law allows it only in the muta form. In the nikah form, that marriage is not possible. So let us summarize. If we want to summarize on this point, how can we say? We can say that a Muslim woman, whether Shia, this point should also be noted, that a Muslim woman, whether Shia or Sunni, has no right to enter into the contract of marriage with any non-Muslim male. Earlier we studied situations where a Muslim male marries with a non-Muslim female. Here we are trying to know what will be the consequence if a Muslim female marries with a non-Muslim male. The answer is that she is not allowed to marry under Muslim law. Such marriage is void. If she marries with a non-Muslim male, then according to Muslim law, that marriage is void. I have summarized and the whole discussion in 5 points. Muslim male of any sect may marry with a Muslim female of any sect. That marriage is perfectly valid. Second, Sunni male may marry a Kitabiya female. Marriage is perfectly valid. Sunni male and the female is neither Muslim nor Kitabiya. Then according to most of the writers' opinion, it is merely irregular. If the male is Shia, he cannot marry with a non-Muslim female in the nikah form. If he does so, then that nikah is void. And the last one is that a Muslim female whether Shia or Sunni, cannot marry with a non-Muslim male. If she does so, under Muslim law, that marriage is void. So these are the provisions according to Muslim law. However, as we all know that there is one act in India, in our country, which is known as Special Marriage Act 1954. This act was especially enacted in order to allow inter-religion marriages. This act allows a person of one religion to marry with a person of another religion. So, two persons of different religions may marry under this act. This act says that if, according to this act, they marry, their marriage is perfectly valid under this act. But since we are studying under Muslim law, we discussed all those things which we earlier discussed. Now, the second requirement, the second formality is that the consent of the parties to the marriage must be free. Where the parties are sane and adult, it is their own consent which is required. We have studied earlier that even minors' marriage under Muslim law is possible with the consent of the guardians. One may ask that this is a child marriage. How does Muslim law allow child marriage? Of course, marriage is possible, but those laws which either prohibit or restrict child marriages, those laws apply on Muslim marriages also. Therefore, anybody who contracts a child marriage attracts punishment under Child Marriage Restraint Act or a newly enacted law which was enacted for prohibiting child marriage. So he attracts punishment. Child marriage is discouraged by these legislations. Here we are studying the consent of the parties, and as I told you, that where the parties are sane and adult, it is their own consent which is required. If the parties to the marriage are minor or insane, the consent of the guardians shall be obtained. A minor cannot, a minor or insane. We just discussed earlier that a minor or a person who is insane, they cannot marry on their own. Then who will give consent for their marriage? Their guardians. And who will be the guardian? We have studied who acts as guardian in marriage. The consent must be free. A consent is said to be not free if it is given under compulsion, fraud, or mistake of fact. If the consent is obtained under compulsion or fraud or mistake of fact, then that consent is not a free consent. Now let us try to understand what happens when the consent is obtained either under compulsion or fraud or by mistake of fact. Under compulsion, according to Muslim law, except under Hanafi school, if the consent of the parties or of their guardians has been obtained under any compulsion, the marriage is void. According to Muslim law, except Hanafi law, if the consent of the parties or their guardians has been obtained under any compulsion, the marriage is void. But under Hanafi law, even if the consent is given under compulsion, the marriage is valid. It's very surprising. Why it is so? Why does Hanafi law say that even if the consent has been obtained under compulsion, the marriage is valid? This is because the Hanafi jurists interpret one hadith, that is one saying of Prophet Muhammad, peace be upon him, which is known as hadith, where he is reported to have said that there are three things which, whether done in joke or earnest, shall be considered as serious and effectual. The first one is marriage, the second one, divorce, and the third, taking back. These are the three things which Prophet Muhammad, peace be upon him, is reported to have said that if they are done in joke or earnest, they will be treated as serious and effectual. This hadith has been so interpreted by Hanafi jurists that they have come to the conclusion that even if the consent is obtained under compulsion, the consent is valid and therefore marriage will be treated to be valid. One may agree with this opinion or disagree, but this is how they have interpreted. And therefore, according to Hanafi law, marriage under compulsion is valid. It may appear to be very, surprising, but the fact of the matter is that their interpretation is such. What will happen in Shia law? According to Shia law, such a marriage is void. The Shia law on this point appears to be more rational. What will happen in case of fraud? Fraud is played when there has been a dishonest concealment of certain relevant facts or a false statement in obtaining the consent for marriage. If the consent is obtained by playing fraud, the marriage is voidable. If the consent is obtained by playing fraud, the marriage is voidable at the option of the party whose consent was so obtained. This must not be forgotten that in case of fraud, under all schools, including Hanafi school, the marriage is voidable. Voidable at the option of the party whose consent was so obtained. When the fraud is found, the parties may either reject or accept the marriage. Where it is rejected, it becomes a void marriage. What will happen in case of mistake of fact? If due to mistake of fact, the parties or any party to the marriage give consent, what will happen? Two persons are said to consent when they agree upon the same thing in the same sense. This statement is used even under law of contract in order to understand the meaning of consent. I repeat, two persons are said to consent when they agree upon the same thing in the same sense. If at the time of marriage both the parties or their guardians are under a mistake of fact relevant to their marriage, there is no consent and the marriage is void. Suppose there is a mistake of fact regarding the identity of the parties. X marries Y. Under the mistake of fact, he thinks that Y is Z. Supposing Y to be Z, X marries with Y. Here there is a mistake of fact. Mistake of fact as to identity of the other party. If the mistake of fact is genuine, then the law says that marriage is void. What are the formalities of marriage under Muslim law? This point is very important and we must understand it with care and caution. See, no religious ceremonies or rites are necessary to validate marriage under Muslim law. There is no religious ceremony or religious rite which has been made necessary or compulsory for validating the marriage. No religious ceremony or rite is made necessary. This is completely true. The only essential formalities are that there should be offer and acceptance made at the same sitting. There should be offer and acceptance made at the same sitting. What is the meaning of offer? Offer, which is also known as ijab, signifies willingness of a person to contract a marriage with the other. Anyone can offer the other person to marry. Acceptance, which is also known as qabul, is made by the other party or guardian. Even in case of offer, if the party is minor, the offer can be made by the guardian. And so is the case with acceptance. The guardian may accept if the party is minor. So, offer flows from one party, the acceptance flows from the other party. No specific words are prescribed for offer and acceptance, but it should not be of uncertain or doubtful nature. It should not be uncertain. It should not be doubtful. It should be crystal clear. The offer should be such that the intention to marry should appear. The acceptance should be such that the party accepting is expressing his or her intention to genuinely accept the offer of marriage. Oral, it may be oral or written. Acceptance or offer need not be in writing. They may be in writing or they may be oral also. When the offer and acceptance is written, this is known as kabinama, which is an important documentary evidence of marriage. It is always advisable, and nowadays most of the Muslims, when they marry, they reduce their contract of marriage into writing. They have written proof nowadays. In old days, people did not bother to reduce the contract of marriage into writing, and therefore oral offer and acceptance used to take place in old days. Even now it happens, and if it happens, the marriage is completely valid. Law does not make it necessary that the contract of marriage must always be in writing. So it is possible that the marriage may be either oral, offer and acceptance may be either oral or in writing. Both are valid. What is the meaning of offer and acceptance must be at the same sitting? What is the meaning of at the same sitting? Remember, this cannot be interpreted literally. This cannot be interpreted literally. That means it is not necessary that both the parties should have been present at one place. It is not necessary. The idea behind this is that the offer and acceptance must be simultaneous to each other, so that they form part of the same transaction. What is important? That offer and acceptance should be made in such a situation and in such a manner that they form part of the same transaction. This means even if two parties are sitting at different places, they are not sitting at one place, they are sitting at different place. Offer is being made by one party, the other party is accepting. Marriage is valid. It is not necessary that both the parties should be present at one place. In some of the books, examples have been given, and in one of the examples I remember where it is said that in old days, suppose A sends offer of marriage by a messenger B to the other party C. B, the messenger, takes the offer, he rides a horse, goes to C and conveys the offer to C. C, after getting the offer of marriage from A, accepts the marriage, accepts the offer. And then the same messenger B comes back to A to convey the acceptance. Now, it may take time, maybe many hours. It is quite possible that it may take days. But here, what is happening? There is a continuity. There is a continuity. The offer was taken, offer of A was taken by B, and it was conveyed to C, and then acceptance of C was taken by B, and it was again conveyed to A. Here there is a continuity. One can say that this is simultaneous because it forms part of the same transaction, and therefore even in this situation it will be said that the offer and acceptance has been made in the same sitting because they form the part of the same transaction. Where it appears that the offer and acceptance are isolated, where it appears that the offer and acceptance are isolated. Suppose A offered B today. B did not accept the offer of marriage. B only listened Ismail did not answer, went home. After a few days, or 1 week or 2 weeks, B comes back to A and says that, oh, you had offered me on the other day to marry, I accept your offer. This offer and acceptance cannot be treated to be at the same sitting. This offer and acceptance, these offer and acceptance, they are isolated, and therefore they do not form part of the same transaction. There is a gap, there is no continuity, and therefore they cannot be treated to be valid offer and acceptance for the sake of marriage. One more point which is very significant is that there should be a reciprocity. What does it mean? Offer and acceptance must be reciprocal to each other. If the acceptance is not for the same offer, it is not a valid acceptance. Acceptance cannot be conditional or with modification. If the acceptance is conditional or with modification, the acceptance is not reciprocal. Reciprocal offer means whatever has been offered should be accepted as such, without any change. If there is no change from the other side, then it will be said that offer and acceptance are reciprocal to each other, and therefore there is reciprocity. Reciprocity is also essential for a valid offer and acceptance. One more significant point is the presence of witnesses. Here there is a difference between Sunni law and Shia law. According to Sunni law, presence of witnesses, competent witnesses, is necessary for a valid marriage. What does it say? It says that offer and acceptance must be made in the presence of at least 2 competent witnesses. This is the provision according to Sunni law. Any male Muslim of sound mind and who has attained puberty can act as a competent witness. If 2 male Muslims are not available, because according to Sunni law, 2 competent witnesses are required. If 2 male Muslims are not available, then 1 male and 2 female Muslims of sound mind and major may fulfill the legal requirement. A marriage without witnesses or with incompetent witnesses is irregular. Remember, if there is no witness, there are no witnesses to the marriage, or there were witnesses but the witnesses were not competent, they were incompetent witnesses, what will be the consequence of that marriage? The marriage will be treated to be irregular marriage. It will not be invalid or void. It will be only irregular marriage. This irregularity is done away with by the consummation of marriage. The moment marriage gets consummated, this irregularity is removed. The marriage becomes fully valid. So, in this situation, the irregularity is a temporary one. As we all know, that the natural consequence of any marriage, especially when the parties are young, is consummation of marriage. And the moment consummation of marriage takes place, the marriage becomes valid. It does not remain irregular marriage. But in case of Shia law, witnesses are not legally required. Witnesses are not required. A marriage without witnesses is completely valid under Shia law. So these are the very fine points which I want to tell you in today's lecture. There are some other portions relating to the essentials of valid marriage under Muslim law we will discuss in the next part. Thank you very much.